Let's talk about prior convictions and whether or not the jury can hear about those prior convictions during a criminal trial, everybody. Here is the answer for our second question regarding the trial zone that I had posed earlier today. Regarding Michael Cohen, can his prior conviction be heard by the jury? And the answer is, it depends. Let me walk you through the process, everybody. First of all, let's take a look here at the New York Rules of Evidence. Now, by taking a look, we want to go ahead to number 6, witnesses and impeachment. So we would click there. Just to show you what that would look like, we're under Article 6 for the Rules of Evidence for New York, witnesses and impeachment, and we will scroll down a little bit. Now, we're actually going to be looking at 2 rules today. It's exciting. First, we'll take a look at 6.19, impeachment by prior conviction, and 6.17, impeachment by misconduct. Friendly reminder, impeachment is when someone is testifying on the stand and we are trying to question their credibility. So use of prior convictions is actually a little bit complicated because it can only be used in certain instances. But let's go ahead and take a look at Rule 6.19, impeachment by prior conviction. Here's Rule 6.19, impeachment by conviction. Subsection 1, the credibility of a witness may be impeached. So again, we can ask about the credibility and kind of present to the jury why this witness may not be credible. Subsection A is in regards to a civil proceeding. We don't need that. We need a criminal proceeding. And B says in a criminal proceeding. Now, the question I posed was whether or not the information regarding Mr. Cohen's conviction could be shared with the jury. So subsection 1 here, except as provided in subparagraph 2, by asking the witness in good faith and cross-examination whether the witness has been convicted of a specified offense. So we need to know whether or not that would be applicable. Number 2, when the witness is a defendant, and that's not what we're dealing with here. And 3, if a witness denies the conviction or answers in an equivocal manner, the conviction may be proved by introducing into evidence a certified copy of the judgment of conviction. So it looks like little I and little 3I would be applicable here. So he can be asked regarding a specified offense. We're going to have to take a look and see what the specified offense means. And then if he denies it, it can be shown to a jury. But we have to be careful here. So let's take a look at the next piece. Subsection 2, a witness's adjudication as a youthful offender under Article 720 of Criminal Procedure Law or an adjudication as a juvenile delinquent under Article 3 of the Family Court Act is not admissible to impeach a witness's credibility. The conduct underlying the adjudication may, however, be used to cross-examine the witness, subject to Rule 617, impeachment by instances of misconduct. So we need to take a look there at Rule 6.17. Number 3, when a witness is impeached pursuant to Subdivision 1, the party who offered that witness may in rebuttal present evidence of the witness's character for truthfulness pursuant to Rule 6.23. This means that if the witness is impeached with that prior conviction of certain kinds of crimes, rebuttal evidence can be shown to kind of rehabilitate the witness, to rehabilitate Mr. Cohen, saying maybe he wasn't so truthful then when he was involved in this crime, but he certainly is now. So rebuttal evidence is allowable. So this is a little bit confusing again. So again, with that question, can we show the jury, can we present to the jury Mr. Cohen's prior conviction? I'm still not 100% sure, so let's take a look at Rule 6.17, impeachment by instances of misconduct, and that will give us a better picture. And here we go, 6.17, impeachment by instances of misconduct, subject to paragraph C. A, the credibility of a witness may be impeached on cross-examination by asking the witness about prior specific criminal, vicious, or immoral conduct of the witness, and B, the credibility of a witness who gives evidence of a person's character also may be cross-examined about whether the witness has heard of prior specific criminal, vicious, or immoral conduct of the witness who was subject of the character testimony. C, cross-examination authorized by paragraphs A and B is permissible if. So we have to go all the way down to C to finally get this answer. First of all, the nature of the conduct or the circumstances in which it occurred bears logically and reasonable on the witness's credibility. That means it has to be a crime that somehow affects the credibility of the witness testifying. Number two, the question has a good faith basis. Number three, the question does not relate to conduct underlying a criminal charge of which the witness was acquitted. And four, in a criminal case, the question about prior criminal, vicious, or immoral conduct of the defendant was authorized by the court prior to trial. All right, let's stop there, everybody. So we've got to meet those four elements in order to have this prior bad conduct that would be a prior criminal conviction in front of the jury by asking Mr. Cohen on cross-examination or various other means. So again, this gets a little complicated. The overall lesson to take away is if there is a crime that Mr. Cohen was convicted of that involves his credibility, it may be used against him on cross-examination in order to impeach his credibility. So that means if he has crimes of other things that aren't involving crimes of credibility, those crimes may not be used. So if there was a crime of assault or possession or kidnapping or some kind of alcohol-related offense, those kinds of crimes cannot be used against a witness when they're testifying. Only prior convictions involving the witness's credibility. So let's take a look at Mr. Cohen's prior convictions and see if he was convicted of crimes that would involve his credibility. And here we go. We've got a set of counts that were set out regarding Michael Cohen. Let's take a look and see if any of the counts involve a crime involving credibility issues. We've got counts 1 through 5, evasion of assessment of income tax liability. Evasion of income tax liability. Is that a crime involving lying or some kind of misrepresentation or credibility issues? Perhaps. Let's take a look at the rest of the counts. Count 6 here says false statements to a bank. There we have it. Any kind of false statements or misrepresentations would equal a crime involving someone's credibility. So yes, count 6 would be that prior conviction of a crime involving credibility. Just for fun, let's take a look at the rest of the counts. Okay, count 7 says causing an unlawful corporate contribution. That could be a credibility issue, but not blatant. Count 8, excessive campaign contribution. Now that's a good question. Is that particular one a crime of credibility question? I'm not sure. And that's it for the counts that were set out here in this document. So it looks like if we're going to really hang our hat on a crime of credibility, we do have one count involved regarding falsifying information given to banks. So yes, I think we do have a prior conviction that would qualify under the rule of evidence. Let's go back and take a look again. So we're looking to impeachment by instances of misconduct under Rules of Evidence 617. We're looking to C for cross-examination authorized, and 1, 2, 3, and 4 need to be present. And I think we definitely have a credibility crime that Mr. Cohen has been convicted of. And then stepping one more back to 6.19, impeachment by conviction. The credibility of a witness may be impeached, again, in a criminal proceeding. And then we step through 1, 2, and 3, and then we can look to subsection 2 and subsection 3. I think we've met the bar, everybody. So, a long explanation to a quick question, but can Mr. Cohen's prior conviction be used against him or be used in front of the jury? Yes, it can, because his conviction involved a crime involving his credibility. Because it involved misrepresentations, because it involved a fraud, false statements, it may be used against him in order to impeach his testimony on cross-examination, everybody. There you have it. Can it be used against him? Yes, it can, but we have to use it very carefully.